UNCITRAL Rules on Transparency in Treaty-based Investor-State Arbitration 1993, Article 1 Scope of Application Applicability of the Rules 1. The UNCITRAL Rules on Transparency in Treaty-based Investor-State Arbitration, Rules on Transparency, shall apply to investor-state arbitration initiated under the UNCITRAL Arbitration Rules pursuant to a treaty providing for the protection of investments or investors. Treaty, concluded on or after the 1st of April 2014 unless the parties to the treaty have agreed otherwise. 2. In investor-state arbitrations initiated under the UNCITRAL Arbitration Rules pursuant to a treaty concluded before the 1st of April 2014, these rules shall apply only when a. The parties to an arbitration, the disputing parties, agree to their application in respect of that arbitration or b. The parties to the treaty or, in the case of a multilateral treaty, the state of the claimant and the respondent state, have agreed after the 1st of April 2014 to their application. Application of the rules. 3. In any arbitration in which the rules on transparency apply pursuant to a treaty or to an agreement by the parties to that treaty. a. The disputing parties may not derogate from these rules, by agreement or otherwise, unless permitted to do so by the treaty. b. The arbitral tribunal shall have the power, besides its discretionary authority under certain provisions of these rules, to adapt the requirements of any specific provision of these rules to the particular circumstances of the case, after consultation with the disputing parties, if such adaptation is necessary to conduct the arbitration in a practical manner and is consistent with the transparency objective of these rules. Discretion and authority of the arbitral tribunal. 4. Where the rules on transparency provide for the arbitral tribunal to exercise discretion, the arbitral tribunal in exercising such discretion shall take into account a. The public interest in transparency in treaty-based investor-state arbitration and in the particular arbitral proceedings and b. The disputing parties' interest in a fair and efficient resolution of their dispute. 5. These rules shall not affect any authority that the arbitral tribunal may otherwise have under the UNCITRAL Arbitration Rules to conduct the arbitration in such a manner as to promote transparency, for example by accepting submissions from third persons. 6. In the presence of any conduct, measure or other action having the effect of wholly undermining the transparency objectives of these rules, the arbitral tribunal shall ensure that those objectives prevail. Applicable instrument in case of conflict. 7. Where the rules on transparency apply, they shall supplement any applicable arbitration rules. Where there is a conflict between the rules on transparency and the applicable arbitration rules, the rules on transparency shall prevail. Notwithstanding any provision in these rules, where there is a conflict between the rules on transparency and the treaty, the provisions of the treaty shall prevail. 8. Where any of these rules is in conflict with a provision of the law applicable to the arbitration from which the disputing parties cannot derogate, that provision shall prevail. Application in non-UNCITRAL arbitrations. 9. These rules are available for use in investor-state arbitrations initiated under rules other than the UNCITRAL Arbitration Rules or in ad hoc proceedings. Article 2. Publication of information at the commencement of arbitral proceedings. Once the notice of arbitration has been received by the respondent, each of the disputing parties shall promptly communicate a copy of the notice of arbitration to the repository referred to under Article 8. Upon receipt of the notice of arbitration from the respondent, or upon receipt of the notice of arbitration and a record of its transmission to the respondent, the repository shall promptly make available to the public information regarding the name of the disputing parties, the economic sector involved and the treaty under which the claim is being made. Article 3, Publication of Documents. 1. Subject to Article 7, the following documents shall be made available to the public: the notice of arbitration, the response to the notice of arbitration, the statement of claim, the statement of defense and any further written statements or written submissions by any disputing party, a table listing all exhibits to the aforesaid documents and to expert reports and witness statements, if such table has been prepared for the proceedings. but not the exhibits themselves. Any written submissions by the non-disputing party, or parties, to the treaty and by third persons, transcripts of hearings, where available, and orders, decisions and awards of the arbitral tribunal. 2. Subject to Article 7, expert reports and witness statements, exclusive of the exhibits thereto, shall be made available to the public, upon request by any person to the arbitral tribunal. 3. Subject to Article 7, the arbitral tribunal may decide, on its own initiative or upon request from any person, and after consultation with the disputing parties, whether and how to make available exhibits and any other documents provided to, or issued by, the arbitral tribunal not falling within paragraphs 1 or 2 above. This may include, for example, making such documents available at a specified site. 4. The documents to be made available to the public pursuant to paragraphs 1 and 2 shall be communicated by the arbitral tribunal to the repository referred to under Article 8 as soon as possible, subject to any relevant arrangements or time limits for the protection of confidential or protected information prescribed under Article 7. The documents to be made available pursuant to paragraph 3 may be communicated by the arbitral tribunal to the repository referred to under Article 8 as they become available and, if applicable, in a redacted form in accordance with Article 7. The repository shall make all documents available in a timely manner, in the form and in the language in which it receives them. 5. A person granted access to documents under paragraph 3 shall bear any administrative costs of making those documents available to that person, such as the costs of photocopying or shipping documents to that person, but not the costs of making those documents available to the public through the repository. Article 4. Submission by a third person. 1. After consultation with the disputing parties, the arbitral tribunal may allow a person that is not a disputing party, and not a non-disputing party to the treaty, third persons, to file a written submission with the arbitral tribunal regarding a matter within the scope of the dispute. 2. A third person wishing to make a submission shall apply to the arbitral tribunal, and shall, in a concise written statement, which is in a language of the arbitration and complies with any page limits set by the arbitral tribunal, a. Describe the third person, including, where relevant, its membership and legal status, for example, trade association or other non-governmental organization, its general objectives, the nature of its activities and any parent organization, including any organization that directly or indirectly controls the third person. B. Disclose any connection, direct or indirect, which the third person has with any disputing party. C. Provide information on any government, person or organization that has provided to the third person. I. Any financial or other assistance in preparing the submission or, 2. Substantial assistance in either of the 2 years preceding the application by the third person under this article, for example funding around 20% of its overall operations annually. D. Describe the nature of the interest that the third person has in the arbitration and E. Identify the specific issues of fact or law in the arbitration that the third person wishes to address in its written submission. 3. In determining whether to allow such a submission, the arbitral tribunal shall take into consideration, among other factors it determines to be relevant, a. Whether the third person has a significant interest in the arbitral proceedings and b. The extent to which the submission would assist the arbitral tribunal in the determination of a factual or legal issue related to the arbitral proceedings by bringing a perspective, particular knowledge or insight that is different from that of the disputing parties. 4. The submission filed by the third person shall, a. Be dated and signed by the person filing the submission on behalf of the third person, b. Be concise, and in no case longer than is authorized by the arbitral tribunal. C. Set out a precise statement of the third person's position on issues and d. Address only matters within the scope of the dispute. 5. The arbitral tribunal shall ensure that any submission does not disrupt or unduly burden the arbitral proceedings. or unfairly prejudice any disputing party. 6. The arbitral tribunal shall ensure that the disputing parties are given a reasonable opportunity to present their observations on any submission by the third person. Article 5. Submission by a non-disputing party to the treaty. 1. The arbitral tribunal shall, subject to paragraph 4, allow, or, after consultation with the disputing parties, may invite, submissions on issues of treaty interpretation from a non-disputing party to the treaty. 2. The arbitral tribunal, after consultation with the disputing parties, may allow submissions on further matters within the scope of the dispute from a non-disputing party to the treaty. In determining whether to allow such submissions, the arbitral tribunal shall take into consideration, among other factors it determines to be relevant, the factors referred to in Article 4, paragraph 3, and, for greater certainty, the need to avoid submissions which would support the claim of the investor in a manner tantamount to diplomatic protection. 3. The arbitral tribunal shall not draw any inference from the absence of any submission or response to any invitation pursuant to paragraphs 1 or 2. 4. The arbitral tribunal shall ensure that any submission does not disrupt or unduly burden the arbitral proceedings, or unfairly prejudice any disputing party. 5. The arbitral tribunal shall ensure that the disputing parties are given a reasonable opportunity to present their observations on any submission by a non-disputing party to the treaty. Article 6. Hearings 1. Subject to Article 6, paragraphs 2 and 3. Hearings for the presentation of evidence or for oral argument, hearings, shall be public. 2. Where there is a need to protect confidential information or the integrity of the arbitral process pursuant to Article 7, the arbitral tribunal shall make arrangements to hold in private that part of the hearing requiring such protection. 3. The arbitral tribunal shall make logistical arrangements to facilitate the public access to hearings, including where appropriate by organizing attendance through video links or such other means as it deems appropriate. However, the arbitral tribunal may, after consultation with the disputing parties, decide to hold all or part of the hearings in private where this becomes necessary for logistical reasons, such as when the circumstances render any original arrangement for public access to a hearing infeasible. Article 7. Exceptions to transparency. Confidential or protected information. 1. Confidential or protected information, as defined in paragraph 2 and as identified pursuant to the arrangements referred to in paragraphs 3 and 4, shall not be made available to the public pursuant to Articles 2 to 6. 2. Confidential or protected information consists of a. Confidential business information. b. Information that is protected against being made available to the public under the treaty. c. Information that is protected against being made available to the public, in the case of the information of the respondent state, under the law of the respondent state, and in the case of other information, under any law or rules determined by the arbitral tribunal to be applicable to the disclosure of such information, or d. Information the disclosure of which would impede law enforcement. 3. The arbitral tribunal, after consultation with the disputing parties, shall make arrangements to prevent any confidential or protected information from being made available to the public, including by putting in place, as appropriate, a. Time limits in which a disputing party, non-disputing party to the treaty or third person shall give notice that it seeks protection for such information and documents. b. Procedures for the prompt designation and redaction of the particular confidential or protected information in such documents, and c. Procedures for holding hearings in private to the extent required by Article 6. Paragraph 2. Any determination as to whether information is confidential or protected shall be made by the arbitral tribunal after consultation with the disputing parties. 4. Where the arbitral tribunal determines that information should not be redacted from a document, or that a document should not be prevented from being made available to the public, any disputing party, non-disputing party to the treaty or third person that voluntarily introduced the document into the record shall be permitted to withdraw all or part of the document from the record of the arbitral proceedings. 5. Nothing in these rules requires a respondent state to make available to the public information the disclosure of which it considers to be contrary to its essential security interests. Integrity of the arbitral process. 6. Information shall not be made available to the public pursuant to Articles 2 to 6 where the information, if made available to the public, would jeopardize the integrity of the arbitral process as determined pursuant to paragraph 7. 7. The arbitral tribunal may, on its own initiative or upon the application of a disputing party, after consultation with the disputing parties where practicable, take appropriate measures to restrain or delay the publication of information where such publication would jeopardize the integrity of the arbitral process because it could hamper the collection or production of evidence, lead to the intimidation of witnesses, lawyers acting for disputing parties or members of the arbitral tribunal, or in comparably exceptional circumstances. Article 8. Repository of published information. The repository of published information under the rules on transparency shall be the Secretary-General of the United Nations or an institution named by UNCITRAL.